Thank you to all of our panelists. If I could ask everybody to return to their seats, and we'll take questions. We have about 15 minutes for questions. So.
Hi, Lisa Kerr, New York University. I so appreciated many of the points in that last talk. As a person who's been in graduate school for 4 years at a law school, there's a lot to discuss at lunch maybe. But I want to really pick up on your legitimate issue with this notion of a divide between practice and theory, and maybe connect it to some of Professor McLaren's points. So Professor McLaren described this 1960s Kansas school and University of Toronto today and the differences there. And you connected it a little bit to the rise of legal realism, first in the US and then arriving in Canada. And I take legal realism to be about, you know, what Richard Posner has called the decline of law as an autonomous discipline, and the idea that law is sort of properly penetrated by scientific and humanist inquiry. And I think it's important to emphasize that the legal realists, whether it's Jerome Frank or Carl Lewin, they really emphasized practice as much as they emphasized theory. They were anti-formalists. They said, let's move away from this pure study of doctrine and rules, dislocated from the rest of inquiry, whether it's practical or theoretical. So I think it's just an important point to say that they wanted a constant interaction between practice and theory. They didn't want to sort of take the law school, and sort of disconnect it from those concerns.
Is that a question for me? Okay. Well, the first thing I can say is I totally agree that there's no stark distinction between theory and practice. And while you were speaking, I was flipping through the paper because I was searching for a quote, again, from Rod MacDonald, I think the inspiration on this panel, who said that abstract theoretical knowledge is a canvas on which students of law learn to paint particular proposals for addressing novel situations beyond the contemplation of general rules. And so there's a tremendous link between the two. And I think that the main point of our paper is, well, there's several points, but the main point is that you can't make these artificial distinctions, and nothing unfolds in watertight silos. And that the best way to approach legal education is to eschew these silos and to think more broadly about legal education as simply how do we teach people how best to help people in their complex interactions with each other, because that's what law is all about.
If I could just add to that, it seems to me that there is a real deficit if one goes through law school without some sense of the society in which one is going to operate, whatever you do in terms of professional vocation. That's one thing, and I'm talking about history and sociology and economics and a whole range of what the knowledge in other disciplines brings to an understanding. At the same time, it seems to me that people who work in law schools, of course, need to interact with the people in those disciplines. But I think increasingly those who go into practice will need to interact with those disciplines, not merely in terms of dealing with an expert witness on cross-examination, but in terms of how we imagine our society in the future and the complexities which it's already producing. In some instances, the palpable breakdown of systems that we have. How can you deal with those? Well, if we think we can deal with them in a series of academic and disciplinary silos, we have our heads in the sand, I'm afraid. So whichever way you look at it, anybody who goes through law school who comes out without a knowledge of those things, it seems to me, really is starting from a very unfortunate position in terms of dealing with the issues, whether it's in terms of their teaching, whether it's in practice, whether it's in terms of policy making, whatever it is that they decide to go into ultimately.
I'll just add one further thing, that we can think about the distinction between practice and theory as well as in terms of academics and practitioners. And that doesn't only exist at the institutional level, but certainly at the individual level as well. So there are many people who combine scholarship and other elements of practice within, their one career. I think in Canada, one example would be Peter Hogg, who is very much a legal scholar, and I think he's the most cited scholar by the Supreme Court, but he's also scholar in residence for a law firm. He provides counsel to various parties who appear before courts. He also provides advice to the Governor General with respect to prorogation, all of those types of things, and combines that within one person. And so the distinction between theory and practice, it needs to be developed at the institutional level in terms of the curriculum that's offered to law students, and it can manifest very much within one individual.
Thanks for those papers, which were stimulating. John, I think I must have missed the memo at U of T because despite being taught by Dick Risk, I always think of myself as a lawyer, not just as a member of the university. And I think that picks up on the comments you were just making about, I think, the falseness of the dichotomy. But the questions I have, one is for Tom and one is for David. My question for Tom is, what is the difference between colonization and accountability? I mean, I think one of the issues that you have is when you have a sort of purely self-defined law school, I'm not sure why you would ever think that it was inappropriate to have to answer questions that were posed by various people who have legitimate questions to ask about your mission and how you're fulfilling it. And with David, my question for you, and this is one I by way of full disclosure, will say that The Lost Lawyer is a book I hate read, to adopt a phrase from Slate. And my question for you, therefore, is one that I would pose to Tony Cronman, which is, where's the client? And I'm not saying that that's the only thing that has to be accounted for, but a lot of those statesman professional models, especially his, write any kind of intelligence or rationality or judgment of the client out of the question. So those are my questions for you guys.
I think if we look at how there's various forms of external accountability, and accountability is certainly important, and it would be folly to suggest that one could ignore those factors because it's not possible. What's more, it would be really ignorant, and there's a danger of it sounding, when you use the metaphor colonization, that it's sort of a xenophobic Luddite sort of proposition that we have. But I think that accountability is really only meaningful if one is ultimately accountable to oneself, and that all of the different forms of external accountability that we have are really geared towards that. Otherwise, all they are is compliance. All it is giving the answers that are going to satisfy those external surveillors. And so I think what our paper is an attempt to do is an invitation to think about, okay, well, do we have the individual and also collective agency to say that we matter enough to ask those questions of ourselves and to not rely on recycled or imported answers, but to actually give them the full hearing that they deserve.
I'm sorry, could I just ask you to repeat the question?
Where's the client?
Where's the client?
Yeah, especially when you have this idea of a lawyer, citizen, or professional, it creates a very top-down model of anything that the lawyer is doing when they are actually engaging in the practice of law. And a better statement of this is Kate Cruz wrote a terrific paper called Against the Cardboard Client, that we have when we talk about models of the lawyer and models of professionalism. We often write the client out of that whole experience, when in fact, when lawyers are doing this professional thing that they do, they're not doing it on their own. There's no lawyer who is out there just lawyering and without that relationship being part of it. So when you have a sense of setting your goals and interacting with the administration of justice or being civic-minded or citizenship, where's the client's voice in all of that? And then from the account, really not there at all. And so I guess I was saying to you, in your account, where's the client?
So I guess I have a slightly different reading of Cronman, especially when he speaks about using practical wisdom to help work with the client to jointly solve the client's goal. To me, that implies deep respect and an endeavor to put oneself in the position of the client. So I actually think that and there's lots of different conceptions of citizenship related to agency, intersubjective communication, taking the perspective of another, the capacity of judgment, that actually have a quite robust notion of lateral human relations that I actually think has incredible practical benefit and actually reflects the vision of a horizontal cooperative relationship that I think is implied by your question.
Hi there. My name's Dana Scott, and I'm the graduate program director at Osgood right now. So I really appreciated the talk, Rosalie and Kate, about the future of graduate legal education. And I wanted to ask you specifically about, you sort of start the talk by breaking down this boundary between scholar, lawyer, practitioner, academic, that kind of thing. And then you end the talk, and this is the part I really liked about it, about, we need to think about graduate legal education as training the next generation of lawyers, right? Training tomorrow's lawyers, you say. Which seems to me that it almost lends towards an interpretation of graduate legal education being about scholars, academics. And the reason I'm wondering about this is because, we hear sometimes from students in our graduate program that they actually feel there are two sort of streams within some of their classes, and I wonder about whether we need to specialize, right, between students who really are trying to get on an academic track, and they want something different from the classroom than others might want that are not on that same track. So, but I want to put to you, if we say, should we specialize? Should we offer these students something different in the classroom? Does that go against your whole breaking down the boundaries kind of question?
That's the question we were afraid someone was going to ask. So you were really paying attention. In fact, that's the question that we grappled with a great deal. So let me say a few things. The first is, should we offer an academic track or should we not offer, specialized tracks? One of the things that I think is we'd be remiss in doing that for one of the fundamental reasons is that people don't often know what they want to do when they start a legal education. So we're very wary of this notion that law schools should specialize or programs should specialize, and some should be sort of specializing in creating this kind of future legal practitioner and these programs. How do you know? I mean, did any of you know you wanted to become a professor when you entered law school? I certainly didn't. And so I think that we still have to go back to non-tracks, sort of specialization tracks, because people don't often know what they want to do. But once they become a graduate student, then that's a different story. And you're absolutely right that there is a tension in our paper between the notion that we think all legal education should be open and creating jurists and teaching people how to think critically with intellectual rigor and creative problem solving, etc. And we do believe that. And we believe that because those are the skills we believe are necessary for whatever track you take. Ultimately, we believe that that's important for both the practitioner and the academic. And so we do stand by our claim that all legal education at the undergraduate and the graduate level should have those sort of virtues to them. At the same time, we recognize that although many graduate students, particularly doctoral students, do not go on to become the future professoriate, in reality, a large number do. And so taking that reality into account, what also should we be doing special to make sure that they're going to be the leaders of tomorrow sitting in this room in 50 years from now or 40 years from now and talking about where legal education is going. But you were right to notice the tension, but we think we can resolve the tension by asserting that we do believe in our general claim about legal education, but yet recognizing that doctoral students are much of the future of it. Kate, do you want to add anything?
Anyone else? I think we've got time for one more quick question.
Frank Snyder from Texas A&M, down in Fort Worth. And I guess what I really like this panel. I think you articulate a great vision of a kind of legal education. And my question is, are you articulating a vision of what all legal education must be? That unless we do this kind of education for everybody, we shouldn't allow them to practice law at all. Because one suggestion that would solve a number of your issues, the colonization issues, the community of learners issues, the graduate issue, would be simply to decouple legal licensing from university legal education and say that you get licensed based on some set of practical skills, and those of you who want to go on and become leaders of society can do what public policy students do, which is to go to the Kennedy School at Harvard. And I'm just interested in your thoughts on that.
I've spoken a lot.
Just one idle thought. I think that certainly for me, and I'm now a retired academic, so I can say these things, propound these heresies, it would be more comfortable for me to live in a world where a university law school was much more part of the academy and leave it to the profession to do the training in skills. The reality is, folks, they couldn't handle it. I mean, if the history of legal education in Canada tells us anything, it is that there come points in time when the profession wants to give up on the educational mission. Right? Sometimes screaming and all of that has happened in Ontario in the 1950s, but they don't want to do it. And the question is then, who else does it? Well, we're stuck with that. And that's part of the tension that we've been talking about and which exists in this room. But that would be my ideal world. You know, let's get on with looking at law as an academic discipline and its relations with other disciplines, and let somebody else. And what Professor Susskind told us today seems to me to suggest that maybe the future is one in which we have a plurality of places that are engaged in legal education. And if that's true, we're going to have to do some fundamental rethinking about where the universities and university law schools sit in that new galaxy that he's suggesting.
I guess just to attempt a realist answer to that question, I think if we look at some of the challenging legal skills broadly conceived that Professor Susskind told us are going to be keys to the future, I don't think that type of, a lot of the sophisticated and difficult skills that is really going to drive success in the legal profession will be able to be delivered quite practically in a bare bones sort of narrow skills training program. If that premise is true, then you would imagine, like you say, a separate system, higher prestige, higher caliber system of legal education. And I think then you're going to have a hard time recruiting. I think you're going to have a funneling of talent, and I think a lot of people, why people go to law schools, they don't know what they want to do. They know that it's going to be a good education, it'll be good on their CV, it'll give them access to prestige, and I think if you take away a lot of those factors and channel them into the narrow skills training part of teaching, then I think you're going to lose a lot of the appeal that brings people into law school in the first place. So I'm not sure if it would be, I'm not sure you're going to draw the right amount of people by hiving off the different notions of value. So I think that there might be seeds of an instrumentalist argument to keeping the different types of value integrated in the same institution.
Well, with that, I think it's time to break for lunch. Before I let you go, I give you a slight misinformation. I said lunch was till 1:30. It's till 1:15. So we'll reconvene here at 1:15. Before I let you go, please join me again in thanking our esteemed panel.